Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty, appearing on behalf of the plaintiff, Cross Street Apartments.
Your name?
Hannah Schumacher.
All right. And folks, where are we on this case?
Your Honor, if the court recalls, we had a first hearing on this over Zoom, and Ms. Schumacher raised an issue with trash collection at her apartment. And I've had a chance to talk to her and talk to my client, so I thought I'd give the court a brief update as to what the issue is.
All right.
And how we're hoping to proceed. The problem is that these are second floor apartments in a two-story building, and the building's lot line is the building's perimeter. So there's no place to put external trash cans. Historically, there have been trash cans on the sidewalk. That's been the way it has been for years and years and years.
This isn't just a trash issue, folks. Legally, this touches on property rights, city codes, and tenant protections. Imagine being told you can't even put your garbage out where you've always done it. It sounds trivial, but it's actually a huge headache in housing law. Recently, the city of Ypsilanti's code compliance people have been ticketing and refusing to allow the trash cans there. There's no place else to put them.
So the city of Ypsi's been ticketing
the owner and tenants for having trash cans on the sidewalk. The problem is we can't put it inside the building. This is one of those buildings where you open up the door, there's a vestibule big enough for the door swing, and then there's a staircase going up to the apartments. So we can't put it inside. There's no place off street to put it because my client doesn't own any place off street. So I think Ms. Schumacher is very reasonably saying, I don't want to drive 45 minutes to my parents' house to get rid of my trash. I don't have a problem with her escrowing the rent. I'm getting up to speed on this now. What I want to do now is go back, read the city's ordinance, and talk to them about this problem and try to find a resolution. So I think the best thing to do would be to kick this back a couple weeks to give me an opportunity to sit and talk to the city and see if we can't find a solution that works for the city, for my client, and for Ms. Schumacher, who absolutely should have a way to get rid of her trash on site.
What do you want to tell me? Thank you, counsel, for that.
I mean, I agree with pushing it back until the issue gets.
So that is very strange to me because I don't think in all the years I've been doing this that not having a place to put your trash has ever been an issue.
New one for me too.
I just have not heard of that. And when you were telling me at the first hearing, I'm thinking to myself, okay, what's this lady talking about? Thank you for getting that clarified because I wasn't sure when you were saying about the trash issue, and then we got the documents, and I'm still trying to. I don't understand. Like you just have no other place to put it.
Right.
Bless her heart. Driving 45 minutes just to take out the trash? That's dedication or desperation. And it really puts the human side into perspective. These legal disputes aren't just paperwork. They affect real people's daily lives.
So what have you been doing?
I've been driving it 45 miles one way to my parents' house to dispose of it properly.
That's not acceptable.
Bless your heart. Okay. Yeah, that's not. Are there other buildings around that?
And that's actually another part of the problem, is that there's another apartment building that my client doesn't own next door, and their tenants also tend to be putting things into any receptacles we have on the sidewalk. And so,
did they have the same issue, you think, or?
I'm not sure about that. It's too early for me to know that.
Gotcha.
But, from my standpoint, Your Honor, I totally understand where Ms. Schumacher's coming from. My client has been diligently trying to resolve the problem, but they haven't involved me. And as you know, attorneys have some other tools that maybe the manager doesn't have. So I'm hoping to sit down and see if I can't work a resolution of this.
And just one other question. So they've been ticketing the owner for the trash that's outside.
So, for example, Jimmy John's is a tenant downstairs in the building, and they've historically had their trash cans outside for years and years. And now code compliance is saying you can't. So My client got a $200 ticket for Jimmy John's trash can sitting outside.
Because Jimmy John's is a tenant of your client.
Correct.
Right.
My client represents the owner.
So, okay. I'm just going to ask this question out loud.
Here's a juicy nugget. Even something as small as a trash can trigger $200 fines. And yes, businesses like Jimmy John's are involved. Ever wonder how old buildings get tangled up with modern city codes? Welcome to grandfathered chaos in housing law.
Oh, I don't expect an answer because you probably, neither one of you probably know. How do you allow a restaurant to open without having looked at whether or not they have the ability to dispose of things? But you would have done that because that's the way they were doing it.
Well, so there's two answers. First of all, what Jimmy John's is doing now is they're keeping the trash cans inside and then putting it out around the collection times. But again, I mean, this building is an older building. I mean, it probably predates the code. My position is these are grandfathered uses because it's been done like this since the beginning of time. But saying that and having code compliance agree with me, there's a long path to walk between here and there.
Oh, have you dealt with the city?
No, I'm sure this is going to be fun.
That's a much longer walk than you probably are.
We're going to find out.
Just going to say that. How much time do you think would be?
I'd like to kick it a couple weeks and then come back by Zoom. I don't want Ms. Schumacher to have to come forward on these things because I don't think we have any factual disagreement between us. We're not going to need a trial. We're just going to need to find a solution.
Okay.
Notice how the court is trying to be practical? Zoom appearances, no trial needed. It's a reminder that not every legal dispute needs a full-blown courtroom drama. Efficiency matters, especially when no one is actually contesting the facts.
And I'm just saying, if for whatever reason you don't get to where you need to be, if somehow or another you interplead the city, then I could foresee a settlement conference with you representing your client, Ms. Schumacher, in the city. Because that's right. She should not have to be doing that.
No, not at all.
All right. So I have 7th, 14th, 21st. Well, it'll be right before Thanksgiving. So which would be better for you, man? Why don't we?
I'm sorry, what was the date?
The 7th, the 14th, and the 21st.
Of November.
If you watch more football, you'd be able to follow right along. Anyway, go ahead.
The 14th.
14th would be.
Or is there a later date?
I have the 21st.
That's fine, Your Honor. I don't expect the city to be moving at the speed of lightning either. So,
your expectations will probably be well, never mind. I'll adjourn this to November 21st, 2025 at
3 p.m.
At 3 p.m. That's an in-person hearing. However, what I will do is I will allow the parties to appear via Zoom given the circumstances.
Appreciate it very much, Your Honor.
All right. Anything else, Ms. Schumacher?
There will be no judgment.
Ms. Schumacher, I do a lot of these hearings. Okay. Right now, don't you even worry about that. I think the ultimate issue is to try to figure out how to solve this problem for you. All right. I mean, certainly for the landlord, but really solve the problem for you. You shouldn't have to be doing what you're doing.
Just to give Ms. Schumacher a little bit of comfort on that issue, she's been very reasonable to work with. She's putting her money in escrow. I don't need an order for escrow. She's going to give me the information on that. And just so you understand, the most likely outcome, if we work this out, would be something called a conditional dismissal. And that would provide that you would then pay the rent because you're satisfied with the situation and the case is dismissed. So I don't see, based on what I know now, any point at which I'm going to ask the judge to enter a judgment against you. I mean, things could change, but I don't see.
And now knowing what I know, even if he asked.
Get it.
All right. Okay. Ms. Schumacher, thank you. You have a great weekend.
Thank you.
Yes.
Okay. What?
He has one more, I guess I should say, in case you have.
What are you telling me?
Call the next one, we'll see if Mr. Rudy puts his evidence.
Wait, you know what? I passed one. Pleasant Lake. Is that council's?
No, that's not.
I didn't think so. So he has one. Okay, I get it. Just whole staff's been out of control. Linden Park Apartments versus Keith Young.
Good afternoon, Your Honor. Norman Goody appearing on behalf of the plaintiff, Linden Park Apartments.
Keith Young. Pardon?
No.
All right. Counsel, if you'd like to take a default, raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead, sir.
Your Honor, the following testimony is given on information believed, formed after a reasonable inquiry into the facts of this case. There's currently rent to retain in the amount of $5,378.40 through today. Court costs in this matter are $159.15. Total amount to retain, $5,537.55. To the best, we did not ask for a money judgment in this case. To the best of my knowledge, the defendant is neither a minor, an incompetent, or in the military service, and Linden Park has kept the property suitable for use as a residential dwelling, if I may approach.
Yeah.
Thank you, sir.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
All right, thank you, sir.
Have a great weekend.
You do the same. Willow Ridge Apartments versus Chandra Kumar Canadian. Give us a second.
Good afternoon, Your Honor. City Judge. On behalf of plaintiff.
The defendant present. Kanayan?
Not checked it.
Not checked in. This is their motion, I think.
Correct. Your Honor, they had indicated that they were going to pay by today. They have not. At this time, we're requesting the writ just to be signed.
All right. I will grant that, them not appearing. I have it in my file, Mr. Katz, and I've signed that.
Okay, thank you.
Right.
Your Honor, I think the escrow was released last week. Is that correct?
That's what I have. Let me just check one thing. I do not have, well, I do have it closed out. So yes,
Okay.
it was sent. All right.
Okay. Great. Thank you
All
very
right.
much, Your Honor. Have a good weekend.
Thank you. You too, sir.
Bye-bye.
Patrick Becker versus Daniel Wolf. Cynthia Wolf and Aaron Wolf.
Good afternoon, Your Honor. Patrick Becker.
All right. Your name?
Daniel Wolf.
All right. And folks, where are we on this case?
We had an agreement to mutually terminate and dismiss the case if they had vacated the property by today. And
Yes.
Unfortunately, I stopped by the property and that's not happening. So I was going to show up and ask for a default judgment against the two defendants who didn't show, and then the ability to try to work something out with Daniel Wolf.
Sir?
We are moving out tomorrow morning. We have mover scheduled at 9 o'clock. We tried getting them for today, couldn't do it.
A mover?
I'm sorry?
You tried to get a mover?
Yes.
And are they busy on Halloween? I don't know. Is that a thing? It might be. All right. Okay, so you're going to move
Tomorrow morning, 9 o'clock is when the movers will be there.
to move out. Okay. You were requesting was a default as to the two non-appearing parties.
Correct.
And then you did not want me to issue a judgment as against hearing, because you said you were going to try to work to the act.
Yeah. So,
Well, tell me what you guys are trying to do, because
yeah. So what happened was rent started becoming late for a few months, and we had a group meeting in early September where I had agreed to, again, mutually terminate and not charge them any money if they just moved out by the end of the month. They explained to me they were having logistical issues and finding a place to live, and I understood that. The property does have a detached garage. It's about 2,000 square feet, so it's large. And I told them, hey, put all your stuff in that garage. You can find a place to go. From what I understand, they're downsizing. Unfortunately, throughout the month of September, they really made no effort to move and didn't go anywhere. They also did not pay rent. I had to file with the court. In October, we went through the same thing. I told them the same thing, that they could have the exact same options if they paid rent. They did actually pay some back rent, which is great. Currently, there's an outstanding balance of $4,921.40. Unfortunately, I don't have a lot of faith that they do have movers scheduled. If Mr. Wolf could show me that they have something, or more importantly, they have a lease signed and they're moving somewhere, I think I'd be more comfortable.
He's holding something.
Please. And I'd be happy to show you the mover schedule on my phone.
Fantastic.
Oh, hold on.
I did not.
Just hold on. You're good.
So
You have a new lease
Yes,
that starts what?
tomorrow.
Got it.
So I'm very, very, very good with that. So I guess what I would ask for is a judgment for the outstanding $4,921.40. I'm not going to worry about next month's rent. They can have tomorrow for free. And I'd be super happy.
And I would argue that, Your Honor.
Pardon?
Mr. Becker has a deposit of $5,700 from us. Of that $5,700, there is rent owing in the amount of $3,900. But he can take from that security deposit. There's a delta of $1,800.
All right, I got you. Can I ask you a question now?
Sure.
You've used the word delta. I understand why you. Well, I don't understand. What did you do for a living?
Engineer.
Yeah, okay. That's why. All right. I mean, I understood what you meant, and I'm just like, all right.
Sorry.
Okay. So, and they're out tomorrow morning. You were going to give that free. Here's what. You got a security deposit, right? That would cover this amount? Is that,
It would.
It would? Okay, why don't I do this? And what I'm going to do is I'm going to decline to issue the judgment. I'm going to put this out 1 week.
Fair.
If they move, that's fine. And then if not, if they move, then you can do the inspection, determine what's owed. If the security deposit is going to cover it, then I don't have to issue a judgment against them. You take the security deposit, delta and all, I guess. I don't know. Okay, I'm using it wrong. I'm a lawyer. Didn't become an engineer because lawyers are never that exact.
Ah, the classic Delta moment. Engineering meets law because when you start doing math with security deposits and back rent, suddenly everyone's an accountant. But here's the legal truth. Security deposits aren't the landlord's money. That mistake could land you in court real fast.
But oddly, my son is going to be an engineer, which is just like, well, yeah, well, my brother was. So I get where he gets it from, but it's like they're too on point. All right. So that's I think the way I'd like to handle it. Do it that way. Give him a chance to move out. I believe him that they can't get somebody today.
Sure.
For whatever the reason. So I'll adjourn it to November 7th, 2025 at 1 p.m. Now, I'll tell both of you this, and maybe communicate with each other. If everything's all set, you've done the inspection, you've got enough to cover the back rent, and you guys would be satisfied in just taking that, being done, they've moved out, everything's all set, I don't need you folks to appear here because then I can just dismiss the case. You wouldn't get a money judgment anyway. You'd be satisfied. Everything be set. Fair enough?
Yeah, my biggest concern, Your Honor, is having my son, having a judgment placed against him. He's moved out of the house several months ago. And
okay. No,
quite frankly, isn't a party to this whole situation that we're in now.
Your son, Aaron?
Yeah.
Okay. And so I'm not going to issue any judgment. If everything's taken care of, everybody's out, the security deposit gets covered. If there's a shortfall in any way, you guys work it out. If there's not, then get that portion returned. Then everybody
We're good.
Okay?
Works for me.
All righty. Thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Take care. David Sawolski versus Lisa Laro. Lisa Laro. And what about Maria?
She's there.
Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much, it's a non-payment of rent case, how much is, you did file it?
I wanted, sorry. I wanted a 1.5 month, $2,400 security deposit. And, now she owes $3,200 in, back rent because, I took
Hold on a
over.
second.
What happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so, for her to stay there, I would want $1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were going to charge $1,600 for October?
Yes, sir. If she paid
then
it,
let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
We had no agreement.
Your Honor, he came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
did you
I
tell her
asked him
that?
24
No,
hours
sir.
to think about it, and I called him back and said, I agree.
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, I for her to stay there, I wanted.
No.
Okay.
You filed this as a non-payment of rent case, saying that she hasn't paid rent.
Yes, sir.
And in that complaint,
Yep.
you basically indicated that, well, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true.
I originally offered her, sir, $1,200 if she paid me that same day.
Okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent, yet you filed a complaint that says that the rental rate is $1,600. Frankly, sir, that's false.
Okay.
Then you don't say, you say no rent is due, right?
Which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one. That's why I feel.
Well, hold on. Just hold on, ma'am. Just
What
take a breath, please. All right. How much did you pay as a security deposit?
Was $2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was
And-
I'm sorry.
And he told me he had no.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically appear at her door and claim that your rent has gone up by a third.
Yes, sir.
On my say-so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the $1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit?
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that?
Pay attention here. This is a lesson for anyone buying rental property. When you step into a leasehold, you inherit responsibilities, not just keys. Ignoring prior security deposits or trying to double charge a tenant. That's a recipe for legal disaster. The judge is basically saying, get it right or face consequences.
That she gave a security deposit to the previous landlord?
Yeah, I have my
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof, but I don't see anything in the beginning of this that you did that's right. At all. Have you asked the previous landlord if he has her security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are end up getting sued. So my question becomes, what do you want to do with this case?
Well, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yep.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
I'll contact.
Moreover, the complaint, while you certainly could amend the complaint The one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights?
Well, because if she put it,
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances, not sure that was any of your business, but that okay, you took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by a third. So here's what I'm going to do. Okay, I'm going to adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're going to have a heck of a time. I'm just going to be honest with you. But that's going to be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time, so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
thank you, sir.
Have a good day, ma'am.
You too.